Here are 4 questions you must ask first before securing an administrator bond. What is an administrator bond? If someone dies without a will, then the probate laws in that state will control what will happen to the property left behind by the person who died. If there is no will, an administrator of the estate is appointed by the court and will be required to post an administrator bond. The administrator bond then guarantees that the person who is the administrator of an estate performs legally and ethically his or her court-appointed duties and protects those in the will against fraudulent acts. This bond covers any financial damages to the estate due to dishonest acts by the administrator. What documents are needed before securing this bond? 1. A complete signed application. 2. Any court document in which the bond requirement is referenced. 3. If the appointment is a temporary or special appointment, advise why the temporary or special appointment is necessary. Recommended documents. 1. A list of heirs to the estate. 2. An explanation of why your client or you're the one being chosen or volunteering to serve as a fiduciary. Is collateral needed for this bond? Broadly speaking, fiduciary bonds or probate bonds don't require collateral, but rather, we are basing the decision primarily on these factors. 1. Credit score. 2. Financial capacity of the fiduciary. 3. Experience. 4. Character. How much does the administrator bond cost? Each situation is different. Usually the cost, also known as the premium, is 0.5% to 1% of the size of the estate. Here is an example of an administration bond in action. Mr. Bergen, a successful businessman who owned multiple residential and commercial properties, recently passed away without completing his will. His kin and successors were in dispute in the disbursement of his assets. An administrator will be appointed to handle the case to properly distribute the estate assets. Usually, Mr. Bergen's surviving spouse is legally entitled to the estate with no issue. With issue, Mr. Bergen's estate, where the net value does not exceed $50,000, will go to his surviving spouse. If Mr. Bergen died without a spouse or issue, his estate will go to his father and mother in equal shares if both are living. If either of them is dead, the estate shall go to the survivor. With no spouse, issue, or living parents, the estate will be split into equal shares over to his surviving brothers and sisters, if any. Administrators are often trusted kin or relatives. Mr. Bergen's married sister Elsie Hammock, who also happens to be his business associate, was elected by his family and petitioned by the court to serve as an administrator. Mrs. Hammock will require an administration bond as a promise to perform all of her duties. If she fails to perform faithfully and not file reports or pay necessary taxes on time, a claim will be made against her bond. Her chosen surety company will pay the money to the court, and she will reimburse the money to the surety that was paid out. To get started with the bonding process, please do not hesitate to contact Surety Bond Authority at 800-333-7800. You can also visit our website at www.suretybondauthority.com and get your free quote today.